A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Thanks for tuning into another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. It is great to have you with us today. Some breaking news here. I'd actually just finished recording a show when we got word from the U.S. Supreme Court in the New York State Rifle and Pistol Association versus New York City lawsuit, and the Supreme Court declaring today that that case is moot. Thanks to New York City, which had defended this law in district court, defended this law at the Second Circuit Court of Appeals. But when the U.S. Supreme Court agreed to take this case, then New York City said, whoa, okay, we're going to change the law. New York State lawmakers said, yeah, we're going to help you change the law. And this challenge to a New York City law forbidding the transportation of a legally owned pistol outside of the city limits, again declared moot by the Supreme Court. They said, well, listen, gun owners basically got their way. The law in question has been changed. Now, New York City gun owners who have a pistol legally registered them, now they can take their firearm outside of the city limits. They can go to a range outside of New York City. They can take their pistol to a second property that they might own. So the question then has been mooted. Now, there was a dissent in this case. Justice Alito, joined by Justice Thomas and Justice Gorsuch, all dissenting. We'll talk about that here in just a minute or two. Also, Justice Kavanaugh concurring with the majority, but writing a separate concurrence saying, yeah, I think the case was mooted. However, I also agree with Justice Alito that we do need to hear some Second Amendment cases because lower courts are running roughshod over our ruling in Heller and McDonald, and they're not abiding by what we said. It's just that Justice Kavanaugh felt like this one was not the right vehicle. So coming up a little bit later on in the program, we're going to talk with the Second Amendment Foundation's Alan Gottlieb about some other vehicles that the court has in front of it. But right now, I want to share a brief conversation I had just a couple of moments ago with New York State Rifle and Pistol Association Executive Director Tom King, the head of the group that brought this challenge to New York City's gun law. Tom King, head of the New York State Rifle and Pistol Association, thank you, sir, for coming on the program today.
Not a problem, Cam. Not a very happy day, though.
No, it is not. Obviously, you were very disappointed with the Supreme Court's decision to moot this case, even though, Tom, in essence, they said you won, right? They said the reason why this case is moot is because New York City changed its law and gun owners got their way. What's your reaction to that?
My reaction is that, if the Supreme Court allows something like this to change their docket. I think that Alito, Thomas, and Gorsuch said it in their dissent. How can we allow someone to change our docket after we've accepted a case by them taking a legal action to moot the case out? The issue is not solved. All it's done is that they supposedly have made it legal for somebody to transport a gun outside of New York City. However, we have yet to see that.
Yeah, absolutely. And are you concerned at all that now that this case has been declared moot and the claims have been remanded back down to the lower courts, are you concerned at all that New York City and New York State, for that matter, got to go ahead and change the law again? And now that the clock has basically reset to zero?
Well, we've been saying that right from the beginning, right from the time they first applied to moot the case. And the fact is that it's a legal ploy. What used to be a justice system in the United States has now become a legal system. And unless you're a lawyer, you have absolutely no way of getting ahead.
Are you and is the organization going to continue to fight this in the lower court? The Supreme Court sent this back down to a lower court to answer a couple of questions that were raised. They said, "Well, we can't handle this now because it basically now you're raising new questions." Is this case going to continue?
We have to talk about that. The Second Circuit. All of these things cost a lot of money.
Yeah.
And if we don't have any hope or faith in the Supreme Court to stand by the Constitution of the United States, then we have a real problem, and we have to reassess everything.
Tom King, head of the New York State Rifle and Pistol Association. Thank you, sir, for coming on the program today.
Thanks, Cam. Always.
So again, a bitterly disappointed Tom King there. I think all of us are disappointed in the court's decision, perhaps none more so than Justice Samuel Alito, who was joined by Justice Clarence Thomas and Justice Neil Gorsuch in a dissent to this per curiam opinion. I just want to quote a little bit from Justice Alito's dissent. He says, the court vacates the judgment of the Court of Appeals, apparently on the ground that this case is now moot. And if that is the reason for what the court has done, the court is wrong. This case is not moot. He says Article 3, Section 2 of the Constitution limits the jurisdiction of the federal courts to cases and controversies. And as a result, we may not decide questions that cannot affect the rights of litigants in the case before us. Nor may we advise what the law would be upon a hypothetical state of facts. This means that the dispute between the parties in a case must remain alive until its ultimate disposition. He says if a live controversy ceases to exist, then we have no jurisdiction to proceed. But in order for this to happen, a case must really be dead. And that only occurs when it is impossible for a court to grant any effectual relief whatsoever to the prevailing party, saying as long as the parties have a concrete interest, however small, in the outcome of this litigation, the case is not moot. Thus, he says, to establish mootness, a demanding standard must be met. And he says that that standard simply was not met in this case. He says the case is not moot because the amended city ordinance and new state law do not give petitioners all of the prospective relief that they seek. They asserted in their complaint that the Second Amendment guarantees them, as holders of premises license, unrestricted access to ranges, competitions, and second homes outside of New York City. And the new laws do not give them that. The new city ordinance has limitations that petitioners claim are unconstitutional, namely that a trip outside the city must be direct and travel within the city must be continuous and uninterrupted. Exactly what these restrictions mean is not clear from the face of the rule, and the city has done little to clarify their reach. At argument, counsel told us that the new rule allows for bathroom breaks, coffee stops, and any other, quote, reasonably necessary stops in the course of travel. But the meaning of a reasonably necessary stop, writes Justice Alito, is hardly clear. What about a stop to buy groceries just before coming home? Or a stop to pick up a friend who also wants to practice at a range outside of the city? Or a quick visit to a sick relative or friend who lives near a range? The city doesn't know the answers to those questions. Based on all this, he writes, we're left with no clear idea where the city draws the line, and the situation is further complicated by the overlay of state law. The new state law appears to prevent the city from penalizing any direct trip to a range or competition outside the city, but the state law doesn't define that limitation. The petitioners wanted to enter competitions in upstate New York more than a 5-hour drive from the city. Could they stop along the way? And if so, how long? The state has not explained its understanding of this limitation, and in any event, prosecutorial decisions in New York are generally made by the state's 67 elected district attorneys. The bottom line, writes Alito, is that petitioners who sought unrestricted access to out-of-city ranges and competitions are still subject to restrictions of undeterminate meaning. And Justice Alito says, look, these restrictions may not seem very important, but that's beside the point for matters of mootness. In other words, you might not think this is a big deal, but it is a big deal because it makes the case a live issue. Now, again, Justice Alito, Justice Gorsuch, Justice Thomas, in the minority of that opinion. Even Justice Kavanaugh said, yeah, I agree that this case has been mooted. However, he said, I also agree with Justice Alito's general analysis of Heller McDonald. And I share Justice Alito's concern that some federal and state courts may not be properly applying Heller McDonald. The court should address that issue soon, perhaps in one of these several Second Amendment cases with petitions for certiorari that are now pending before the court. And join us to talk about a couple of those cases, the Second Amendment Foundation's Alan Gottlieb, who I spoke to just a short time ago. Take a look and a listen. Let me first ask you, what is your reaction to the Supreme Court's decision today mooting this case?
Well, I wish they didn't moot it because these issues need to be addressed at the highest level. However, I understand why it got mooted when New York changed their law and took it off the books. They made themselves an argument that the case no longer is valid. However, in this decision, the opinion written along with it about the need to hear another case that's pending before them to resolve these problems warms my heart, because the Second Amendment Foundation has 4 current cases pending cert with the United States Supreme Court, and I'm hoping to take one or all of those and resolve this problem once and for all.
Are you concerned that New York City set a precedent here that you can defend a gun control law in court all the way up to the Supreme Court, and then if it looks like the court's going to rule against you, you just tweak the law? Are you concerned about that happening in any of the pending cases that the court has under review?
No, I'm not in these particular cases for that happening. On the other hand, it's a very bad precedent to allow cities like New York to do that when they know they're going to lose a case for the Supreme Court, and then just change the law at the last minute, moot it so you don't get a ruling. That doesn't make good constitutional law. I think the 4 cases pending before them are a lot harder for the jurisdictions to be able to do that. So as a result, I feel pretty good and confident that those cases wouldn't be mooted. I just hope that the Supreme Court decides to grant cert and hear those cases.
What are the issues raised in those 4 cases, Alan?
One of them deals directly with gun confiscation, where the city of San Jose took a woman's firearms that she's legally allowed to own, because her husband was not allowed to own firearms, and these were hers, locked in a California proof safe. She's the only one that had the combination to. And then they said in court, well, we're not giving them back, but she's legally allowed to own guns. She can go buy new ones if she wants to, but she can't have her current ones back. I think that's one that we're going to win on if the court takes that case. We also have one known as Pena out of California, the Ninth Circuit, that deals with their so-called handgun roster and microstamping provision that can't be complied with. So no new semi-automatic handguns can get added onto the list to be sold in the state of California. An example like Glock Gen 4. And at the same time, guns keep falling off the list because they aren't made anymore. And so the problem then is that each year about 10% of the available handguns in California for sale now become banned, so to speak. And eventually there won't be any guns for sale in California. I don't think that's one that the state's going to change the law on, so I think we're in good shape on that as well. And then we have the case known as Mance that deals with the sale of interstate handguns. Now that we have national instant checks, it's the same check all over the country. The reasons for that law, when it was passed way back when in 1968, are no longer valid. And so I think we have a good chance on that one as well. And then one of the other cases deals with the restoration of rights, where a person committed a misdemeanor that now disqualified them from being able to own a handgun under federal law, even though they're allowed to own one under state law. And we want to clear that up, that not a nonviolent misdemeanor shouldn't prohibit you from owning a gun for the rest of your life.
All right. Alan, listen, I appreciate you taking a couple of minutes, sir. Thank you so much for your time. Thanks for what you're doing out there.
You're welcome. Have a great day. Thank you.
Now, in addition to those 4 cases that Alan mentioned, there are a couple of other cases that the Supreme Court is also considering. A couple of them actually involve challenges to the right to keep and bear arms. There's a case out of New Jersey, Rogers versus Grewal, that challenges the state's may issue a status for concealed carry, basically the good cause or good character requirement. You cannot simply go in New Jersey and say, hey, I want a concealed carry license. And they say, okay, well, here, fill out this paperwork and pass the background check and you're good to go. You have to give a specific reason as to why you are special, because the average New Jersey resident cannot acquire a license to carry. And if you can't have a license to carry, you can't carry. So the average New Jersey resident is being deprived of their right to bear arms. It is not just the right to keep, it is the right to bear. The Third Circuit Court of Appeals has upheld New Jersey's concealed carry law. There's also a challenge in the Fourth Circuit, or out of the Fourth Circuit, to Maryland's concealed carry law, which also requires good cause. And you still have challenges out of the Ninth Circuit as well. So the lower courts have been debating the right to carry and basically declaring it null and void in most jurisdictions for a number of years. We had a case called Peruta out of California, and the Ninth Circuit twisted itself into knots to try to come up with a decision that would empower counties in California to have these good cause requirements. And what they found was, listen, there's no constitutional right to carry a concealed firearm, they said. So since there's no constitutional right to carry a concealed firearm, well, then you can do whatever you want with these concealed carry permits because you don't have a right to carry a concealed firearm. Okay, well, what about a right to open carry a firearm? In the time between Peruta being filed and the Ninth Circuit issuing their opinion, the state of California had actually banned the open carry of firearms. But the Ninth Circuit said that that wasn't a part of the original claim in Peruta, and so they didn't have to weigh in on the merits of whether or not the Second Amendment actually protects a right to bear arms in some form or fashion. Then along came a case called Young versus Hawaii that challenged a ban on the open carry of firearms in Hawaii. You had to get a license to open carry. Hawaii doesn't give licenses to open carry. And Mr. Young sued. And a three-judge panel in the Ninth Circuit said, well, if you don't have the right to carry a concealed firearm, and the Second Amendment says you have a right to bear arms, I guess that means you must have a right to openly carry a firearm then, right? That case has been in the Ninth Circuit in an en banc status. So a broader panel of judges have been sitting on this case, basically waiting for the outcome in New York State Rifle and Pistol Association versus New York City. They've been able to play that waiting game again because of the court's consideration of this New York City gun case. Now that the court has said, all right, well, this case is moot, we don't have to reach any answer on the merits of this case. We're just going to kick it back down to the lower court for any of these quote unquote new complaints. Now the Ninth Circuit finds itself in a pickle. They cannot rely on the court for any guidance. They can't say, well, we wouldn't do this, but the court's making us. Now they're going to have to decide on their own. How do you get out of this conundrum where you've stated, all right, you don't have a right to carry a concealed firearm under the Constitution, got the right to bear arms. California, Hawaii, other states have a ban on the open carry. What do we do here? So not only is the Supreme Court going to be considering, not only do they have a half dozen or more cases that they can now consider, and if they want to take Justice Kavanaugh's advice, pluck out one of these Second Amendment cases and say, all right, we're going to hear this case. They've got some other cases, and we have some other cases that are currently percolating in the circuit courts that are also going to be impacted by the Supreme Court's decision to moot New York City or New York State Rifle and Pistol Association versus New York City. Again, I am disappointed in this decision. Like Alan Gottlieb, I'm not necessarily surprised. This was the big topic of conversation at oral arguments. The bulk of the time was spent considering whether or not this case had been mooted. I agree with Tom King, though, that, again, this sets a really bad precedent. And, thankfully, I also agree with Alan Gottlieb, thankfully, the Supreme Court the states are, in the cases that are currently before the court, probably not as likely to change their law in order to avoid a Supreme Court decision. But I say probably. And the reason I say probably is because we have a couple of carry laws on the books right now, thanks to the fact that the Supreme Court was going to hear these cases. In Illinois, the Seventh Circuit Court of Appeals ruled that the state's ban on the carrying of firearms violated the Second Amendment. And rather than risk an appeal to the Supreme Court, even though the state of Illinois had lost that case, they decided we're going to go ahead and we're going to just change the law. We're going to wait for the court to do anything. We're just going to change the law, and they passed a shall issue concealed carry law. And a couple of years later, we now have more than 30,000 residents in the city of Chicago who are concealed carry holders, and hundreds of thousands more across the state of Illinois. Washington, D.C. also had a good cause requirement for its concealed carry because they wanted to deprive as many people as possible. They were sued, and the D.C. Circuit Court of Appeals said, hey, guess what? That good cause requirement violates the Constitution. Now, Washington, D.C. could have appealed this case up to the Supreme Court. They declined to do so as well. And gun control advocates argued, don't appeal this case. This will set a nationwide precedent. Just bite the bullet, no pun intended, and change your law, make it as onerous as possible. You can still require all kinds of training that actually isn't offered in the District of Columbia. You can do all of that, but make sure that you get rid of that good cause requirement. And Washington, D.C. did so. So already we've seen two states, a state and a federal district, change their carry laws in order to avoid Supreme Court scrutiny. Will the same thing happen in New Jersey and Maryland? You got to expect And you got to think that there is intense lobbying right now. Again, for Governor Hogan there in Maryland, for Democrat lawmakers in Maryland, for Governor Phil Murphy in New Jersey, for State Senate President Steve Sweeney in New Jersey as well. Because it's not going to be as easy as it was in Washington, D.C. and Illinois to change the law. In New Jersey, again, Governor Phil Murphy, no friend to the Second Amendment. So would he and the Democrats in control of the state legislature actually go back and pass a shall issue concealed carry law in order to avoid Supreme Court review? I mean, I would find that really surprising. Same with not necessarily the same with Governor Hogan in Maryland. Governor Hogan actually has done what he could in the executive branch to ensure that folks can get a concealed carry license. And he got dinged for that by lawmakers in Annapolis, taking away his ability to put folks on the handgun review board. And they've made, they've taken steps to make it impossible for the average resident of Maryland to obtain and acquire a concealed carry license. So would lawmakers in Annapolis reverse course and all of a sudden say, okay, fine, we'll go shall issue? Again, I tend to doubt that. That would be, stranger things have happened. Rahm Emanuel got on board a concealed carry law, for the state of Illinois. But I'm not sure that gun control advocates are going to be able to convince the lawmakers in both of those states to actually take that step going forward. One thing we do know is that the New York State Rifle and Pistol Association versus New York City case is not going to provide any sort of help for the challenges that we are currently watching around the country related to the coronavirus gun store closures. It was my hope and the hope of a lot of folks that the Supreme Court would weigh in, would say that, you need to take a look at these restrictions with the highest level of judicial review, strict scrutiny. And that would mean that a lot of these challenges would fail on their face because they're not narrowly tailored to serve the public interest in the least intrusive means possible. Without that Supreme Court guidance, we are likely to see lower courts continue to give great deference to any gun control law that is passed by lawmakers or put in place through executive action, unfortunately. And it is not going to be a quick thing for the court to take up another Second Amendment case. Even if they were to announce, on Friday of this week, okay, here are our orders, here are the new cases that we're taking. You're probably not going to get oral arguments for a period of several months, and then you're looking at another 6 months or so before you could get a decision. Oral arguments were held in New York State Rifle and Pistol Association versus New York City back in December. We were expecting maybe an opinion coming in June. We got it in late April. But it is not a quick thing. Even once the court agrees to hear a case, it's not like we're going to get an instantaneous decision. So this is, without a doubt, a setback for the Second Amendment. It may be a setback because New York City and New York State caved in terms of this particular law, but in terms of the greater litigation and the need for the Supreme Court to weigh in on one of these cases, well, I think that need becomes more acute than it ever has been. So that is a look at the breaking news here on this Monday regarding our right to keep and bear arms, the Supreme Court of the United States, the New York State Rifle and Pistol Association versus New York City case. I appreciate you tuning in. Appreciate Tom King and Alan Gottlieb both taking a few minutes today to talk with us. We will be back tomorrow with more of the latest Second Amendment news and information from all across the nation. We will hopefully have more reaction for you as well. We have a lot of other news that I want to get to, including a ban on the open carrying of firearms in Jackson, Mississippi that might be ripe for a court challenge, although I don't know how quickly the Supreme Court might get that particular case. In the meantime, don't forget, you can subscribe to Town Hall Media at YouTube or Bearing Arms Cam & Company on the Apple Podcast. That way you never miss a program. Thank you as always for watching, listening, for spreading the word. And until we talk again, be safe, be well, and be free. And we'll see you here soon with another edition of Bearing Arms Cam & Company.